Hello, this is a talk about the new subject access code issued by the Information Commissioner on the 12th of August 2013. My name is Declan O'Dempsey. I'm a barrister at Cloisters Chambers. The starting point has to be a consideration of what personal data is. The Data Protection Act 1998 stipulates that information must relate to a living individual, and it must allow that individual to be identified from the information, either on its own or in conjunction with other information. The context in which the information is held and the way it's being used can have a bearing on whether it relates to an individual, and therefore on whether it's that individual's personal data. The other concepts that you need to be familiar with include the concept of a data controller. And if somebody determines the purpose for which and the manner in which the personal data is processed, then they or their organisation will be the data controller in relation to that personal data. They'll be responsible for responding to a subject access request, or SAR. The code advises that information systems should facilitate dealing with SARs. They should have the technical capability, but they should also operate by reference to effective records management policies. So it's good practice to have a well-structured file plan and standard file naming conventions, and there needs to be a clear document retention policy. The basic right under the Data Protection Act is contained in Section 7. This provides that the individual's got the right to be informed by the data controller whether any personal data of which that individual is the data subject are being processed by or on behalf of that data controller. So that's right number one. If it is being processed, then the individual's got the right to be given by the data controller a description of the personal data of which the individual is the subject. Secondly, the purposes of the processing. Thirdly, the recipients or classes of recipients to whom they're going to be disclosed. The third right is to have communicated to the individual in an intelligible form the information constituting personal data of which the individual is the data subject, and also any information available to the data controller as to the source of those data. Lastly, if the processing of the data is by automatic means, and the individual is the data subject of that data, and it's being processed for the purposes of evaluating matters relating to the individual, for example, performance at work, creditworthiness, reliability or conduct, if that material constitutes the sole basis for any decision significantly affecting the individual, then the individual's got the right to be informed by the data controller of the logic involved in that decision making, but not to the extent that the process constitutes a trade secret. The code says that the underlying purpose of the Act is to enable individuals to find out what personal data the data controller holds about them, why the data controller holds it, and who the data controller discloses it to. The code regards that as fundamental to good information handling practices. So it's a kind of touchstone for working out whether or not what the data controller is doing is compliant. So what is the subject access request? The request doesn't have to be in any particular form other than in writing, and the controller can't insist on the use of a particular means of delivery. If the request doesn't mention the Data Protection Act specifically, or even say that it's a subject access request, it can still be valid, and it should be treated as if it is valid if it's clear that the individual is asking for their own personal data. The code says, therefore, that everybody in the organisation should be able to recognise a subject access request. It goes on to say, however, that they can come in by any written means, including social media, to which the organisation subscribes. If the organisation doesn't want to reply by social media means, then the controller should ask the applicant for an alternative address to which the information can be sent. In the case of public authorities, sometimes people will send in what's named a Freedom of Information request, but is not, in fact, appropriate for freedom of information. And the code says that if in fact it's dealing with personal data, they should treat it as a subject access request. An issue arises in relation to children, and the central issue is whether the child is mature enough to understand their rights. And the code makes recommendations about borderline cases and refers to various factors which a data controller may take into account in assessing whether or not to respond to the child rather than the parent or guardian. And it recommends as a reasonable approach the Scottish approach, which is that a child of 12 years of age is capable of making a subject access request. So the right then consists of the right to be told whether any personal data is being processed, to be given a description of the personal data, the reasons it's being processed, and whether it'll be given to any other organisation or people. You've got the right to be given a copy of the personal data and given the details of the source of the data where that's available. The question, however, arises what point in time is the data controller obliged to sample the data? The information has to be supplied by reference to the data in question at the time when the request is received. However, it can take account of emendations or deletions made between that time and the date of supply, if those amendments or deletions would have been made regardless of the receipt of the request. For organisations who are subject to the Freedom of Information Act, it's a criminal offence to make an amendment with the intention of preventing disclosure of the information. However, the code makes it clear that regardless of any criminal offence, it is not acceptable to the Information Commissioner's Office to behave in this way, and that applies to all data controllers, not just those who are subject to the Freedom of Information Act. So it's necessary to have a written request, but there are other conditions. These are dealt with in Section 7.2 of the Data Protection Act. So in addition to being in writing, there has to be a fee paid in most cases. This will be £10, or the maximum will be £10, save if it concerns health or education records, and then it may be £50 depending on the circumstances. Credit files are also treated differently in this respect. Another condition is that the data controller is not obliged to provide the data if the data controller hasn't been provided with information which they have reasonably requested of the requestor so as to identify the requester and or locate the information. However, the code makes clear that the controller should make reasonable adjustments for disabled people who find it difficult to communicate in writing. Reasonable adjustments could include treating a verbal request for information as though it were a valid subject access request. If the request is complex, it would be good practice for the data controller to document it in a format which is accessible to the disabled person, and then to send it to the disabled person to confirm the details of the request. So the controller can refuse to provide information until the requestor has supplied sufficient information to identify themselves. Well, the code gives guidance on this. The data controller should ask for enough information to judge whether the person making the request is the individual to whom the data relates, or a person authorized on their behalf. But it emphasizes that the controller must be reasonable about what it asks for and shouldn't ask for a lot more information if the identity of the person making the request is obvious to them. On the other hand, it suggests that if the request is made via a social networking website, it would be prudent to check whether it's a genuine request. And the point I suppose being made is that you need to look at the validity of the route by which the request reaches you if you're a data controller. And for those making requests, it is far more secure for you to make your request by some other means. The second thing that the controller can refuse to comply with the request over is the location of the data. The controller can ask the requester for such information as the controller reasonably needs to find the personal data covered by the request, and doesn't need to comply until they've received it. However, you can't use that to delay compliance, even if the relevant information is difficult to find and retrieve. Secondly, the controller must be reasonably requiring the additional information to help them find the data. Third, the controller can ask the requester to provide information about the context in which the information about the requester may have been processed, and about the likely dates when the processing occurred, if that will help deal with the request. However, the controller is not entitled to ask for the request to be narrowed. The code says that it's reasonable for the data controller to ask where the data is in electronic form for information on the type of electronic data being sought, e.g. an application form, a letter, an email, etc., and roughly when the data was created, because this may help the controller identify whether the information sought is likely to have been deleted or archived. So it may have been printed off and held in a manual data archive, or removed from the live electronic data systems and held in an electronic archive.